camera because it is blurry. And yeah, if you can fix it. Okay. And I would also request then that before we can start, I can see that people are still coming through. People are still coming through. But we need just to respect time and to start as we have purposed for this gathering. All right. My name is Advocate Praise Kambula, and I will be your moderator for this session. And I would just like, as we begin, just to say that we are running a series of webinars. The launch was yesterday. It was done by the Deputy Minister for Justice and Constitutional Development. And the series is about us unpacking the 3 amendment acts that have been introduced. As you know, that the President assented them into law on the 25th of January 2022. So we are. Can I just ask then that people, if you can just, would you please just switch off your mic as you are coming through? We request that you switch off your mic. Can I ask then the administration to switch off the mic? All right. May the administrators switch off the mics of the people who are coming through with open mics, please. All right, as I was saying, we are holding these webinars so as to simplify what the changes are bringing on this platform. As we know that in 2018, women marched throughout the country, and one of the demands was that we needed to have laws that are victim-centric. And if you talk about the criminal justice system, it is somewhat nebulous, particularly for people who are unfamiliar with the ground. So what it means is that we need to come up with interventions and services that will be assisting us to alleviate that pressure, the trauma, and on people when they come to the system. All right, so today it's the second webinar, because we have a series of webinars and we're inviting you to attend. They're going to be running for the whole month of July and coming through with topics that are brilliant, informative, assisting us then to be able to navigate, the new changes that have been introduced by the 3 Amendment Acts. And I want you to know that it's quite a lot of them. And if you are the actor in the criminal justice system, or you are participating, providing certain services and so on, you need to go through all of these, because the infrastructure for the criminal justice system, the legal framework has changed, significantly, particularly in domestic violence. So today, our focus is on the Criminal and Related Matters Amendment Act that introduces certain changes for the intermediaries. So we'll be having 2 presentations today, and I am asking that we switch off all our mics so that the person, only one switch off the mics, and also our cameras as well, so that we only have one camera switch off, which will be for the presenter at that time. I'm requesting that we switch off our cameras. Can we switch off our cameras? Thank you. So we will only have one camera on, that will be for the person who is on the platform. All right. Switch off our cameras. We switch off. Can we also switch off our mics? Noma Somi, we are asking you that you switch off. Can I ask then, please, the administrators, if you can, as soon as a person is coming through with an open mic, would you please just switch it off? Thank you. We're going to be having the first presentation. As I've said, that is 2 presentations today. We'll have the first presentation that will be coming from the Regional Court President, Ms. Yagi Vessels. Ms. Yagi Noma Somi, if you can switch off your mic. The Regional Court President, Yagi Vessels, is part of the Pillar 3 initiative, Pillar 3 collaborative for the NSP, and is also the Regional Court President in Limpopo, and is somebody who is participating in a number of international formations that deal with issues that relate to gender-based violence and femicide. And he's doing a lot of work in this ground, and is one of the person who also influenced certain changes that we have introduced in intermediary services. And if she wants something, it gets done. It gets done. So she is one of the voices that are actually crafting the legal framework in South Africa and making it better for us as women of South Africa and men in South Africa. So I'm handing over to you, Ms. Yagi Vessels. Thank you.
Oh, thank you very much for that introduction, Advocate Kambula. Yeah, we all have to try what we can. Just want to check whether or not the presentation is up.
Yes, it is. Thank you.
Thank you very much. I've been requested to talk today about the specific provisions that impact on intermediaries in the Criminal and Related Matters Amendment Act. So I thought it might be good to just start first with the current provisions until the end of the month dealing with intermediaries. We have currently Section 170, capital A in the Criminal Procedure Act that makes provision for the use of intermediaries for witnesses that is under the mental or biological age of 18 years. And we also have a provision in the Children's Act, Section 61, that deals with participation of children, that a child who's a party or a witness in a matter before a children's court may be questioned through an intermediary as provided for in terms of Section 170, capital A of the Criminal Procedure Act, if the court finds that this would be in the best interest of the child. So these are the provisions that we currently are working with in that make provision for the use of an intermediary to assist the witness in a case, be that in a criminal court or at the children's court. Now, about the role of the intermediary, in the seminal judgment of Deputy Director of Public Prosecutions, Transvaal versus Minister of Justice and Constitutional Development and others in 2009, the Constitutional Court mentioned the fact that the law did not pay much attention to the stress that child complainants in sexual offences cases suffer when they testify in courts. Now, though the Constitutional Court were referring here to child complainants and sexual offences, what is stated here is really applicable to most victims and witnesses that testify in court, and in particular in regards to gender-based violence cases, that they are required to relive the horror of the crime in open court, the circumstances under which they gave evidence, and the mental stress or suffering they went through while giving evidence, that they can be subjected to the most brutal and humiliating treatment by being asked to relate the sordid details of the traumatic experience that they've gone through. And in this regard, the Constitutional Court stated that our constitutional democracy seeks to transform our legal system. Its foundational values of human dignity, the achievement of equality, and the advancement of human rights and freedoms introduce a new ethos that should permeate our legal system. And in this regard, if one looks at the right to equality in the Constitution, it also specifically states the right to equal benefit of the law. And as we know, we're dealing here with substantive equality. And therefore, sometimes you do need to make sure that in order for people to have equal benefit of the law, to fully participate in court proceedings in particular, that they be treated differently. In other words, that there be protective measures that will assist them and ensure that they're actually able to fully participate in court proceedings. In the Constitutional Court decision of DPP Transvaal versus Minister of Justice, the Constitutional Court accepted that testifying in court carries with it a certain degree of mental stress or suffering, that the objective of 170 capital A in the Criminal Procedure Act is to reduce to the minimum the degree of stress and to create an atmosphere that is conducive to speak freely about the events relating to the offense committed against him or her. And with reference to the intermediary, that this is a person that knows how to communicate with the child and to do so in a manner that is neither intimidating nor embarrassing, and acts as a link to breach the communication gap between the child and the court. Now, taking those principles further, where we are when we look at the amendments that was brought about by the Criminal and Related Matters Amendment Act to extend this specific protective measure to other witnesses than children. So the Criminal and Related Matters Amendment Act is therefore amending the Criminal Procedure Act to further regulate the appointment, oath, and competency of intermediaries and the giving of evidence by a witness with physical, psychological, or a mental disability. It further amends the Magistrates Court Act as well as the Superior Courts Act to again provide for the appointment of intermediaries and the giving of evidence through intermediaries in proceedings other than criminal proceedings. As I've mentioned, currently, apart from the provision in the Children's Act, the only provision in law for the use of intermediaries really had been the one in the Criminal Procedure Act. And by amending and including it into the Magistrates Court Act as well as the Superior Court Act, the ability to testify using an intermediary is now extended to all kinds of, basically all types of all types of court proceedings. And obviously the oath and competency of an intermediary is also included in these acts through the amendment. I first would like to quickly talk about the amendments to Section 170 capital A of the Criminal Procedure Act. Subsection 1 had been substituted. Now, it includes not only witnesses that would be under the biological or mental age of 18, but also any witness who suffers from a physical, psychological, mental, or emotional condition. I think there's a mic open somewhere.
Luando, can you deal with this mic? Please, I'm requesting people as you are entering this webinar, if you can just switch off your mic. Thank you.
Oh, thank you. Apologies. So it is including a witness that is under the biological or mental age of 18 who suffers a physical, psychological, mental, or emotional condition, which is new, as well as who is an older person as defined in Section 1 of the Older Persons Act, and that is women over 60 and men over 65. And if any of these types or categories of witnesses would be exposed to undue psychological, mental, or emotional stress, trauma, or suffering, if they testify at such proceedings, the court may, subject to subsection 4, appoint a competent person as an intermediary in order to enable such witness to give his or her evidence through the intermediary. So the first important change is the categories of witnesses that can be assisted with an intermediary. The big change that is further brought in through the amendments to Section 170 capital A is subsection 11 that deals with the oath to be taken by the intermediary. It provides that any person who is competent to be appointed as an intermediary must, before commencing with their functions, take an oath or make an affirmation subscribed by him or her in the form set out below before the judicial officer presiding over the proceedings. So for the first time now, we actually got a prescribed format of the oath or the affirmation. Essentially that they would swear or affirm that when they're called upon to perform the functions, they shall truly and correctly, to the best of their knowledge and ability, perform their functions as an intermediary and convey properly and accurately all questions put to a witness, and when necessary, convey the general purport of any question to the witness unless directed otherwise by the court. Therefore, catering for when they have to simplify the questions and break it up to make it easier for the witness to be able to understand and to respond. The further provisions that is now included specifically is that subject to subsection 13, which we'll deal with just now, before a person is appointed to perform the functions of an intermediary, be that in a magistrate's court for a district or a regional division, the magistrate presiding over the proceedings, or in a superior court, the judicial officer presiding over the proceedings, must inquire into the competence of the person to be appointed as intermediary. So it is incumbent upon the presiding officer to ensure that they have to inquire into the competence of the person to be appointed. Then the aspects the inquiry needs to consider is then specifically included in the legislation now as well, that it must include, but it's not limited to the following: the person's fitness as a person to be an intermediary, the person's experience, which has a bearing on the role and functions of the intermediary, the person's qualifications, the person's knowledge, which has bearing on the role and functions of an intermediary, the language and communications proficiency, and the ability to interact with the witness that is either under the biological or mental age of 18 years, or ability to interact with a witness who is suffering from a physical, psychological, mental, or emotional condition, or their ability to interact with a witness who is an older person as defined in the Older Persons Act. So these specific aspects must be included when the inquiry is done in respect of the competency by the presiding officer. Now, in this regard, it is also important to note what was mentioned in the Constitutional Court decision of DPP, Transvaal versus Minister of Justice, where it indicated that Section 170 capital A must be construed as to give effect to its object, to protect complainants from exposure to undue mental stress or suffering when they give evidence in court. It's about when they are giving evidence. And the Constitutional Court had held that an inquiry to appoint an intermediary should not be approached like a civil trial in which the case state bears the burden of proof to establish a need for the appointment on a balance of probabilities. And it was held that if you do that, such an approach would overlook the essential objective of the section, which is to avoid secondary trauma. Coming back to the amendments, one of the aspects that is really been something that we have been asking for quite a long time, whenever you have to have in each and every case, you need to appoint the intermediary, you need to do the inquiry, you need to swear them in, and on average, it will take you probably about 20 minutes before you can actually start with the testimony of the witness. And for a long time, the issue had been raised, but is there not a way that this could be done upfront without having to do it for each and every case? So in the amendments, they brought in a provision that to the effect that the head of a court may, at his or her discretion, and after holding the inquiry that was contemplated in subsection 12 that we just referred to, issue a certificate in a form prescribed by the minister by notice in the Gazette to a person whom he or she has found to be competent to appear as an intermediary in the court concerned. Now, my co-facilitator, Virginia, will talk about the prescribed certificate that they're working on. And it's also important to note that Section 13E states that for the purpose of this section, head of a court means the most senior judicial officer of that court. Now, if you look at other legislation, for example, the Superior Courts Act referring to the head of court, it would refer to the judicial head. So in this regard, it would be proposed that this would mean that for the regional courts, the most senior judicial officer for the regional division would be the regional court president, and for the district court, the most senior judicial officer for that district court would be the head of that administrative region. So that's the chief magistrate, that is the head of that administrative region. Now, before the head of court can issue the certificate, we have to not only do the inquiry, but then we would also need to cause the person who had been found competent to be appointed as an intermediary to take the oath or make the affirmation, and then endorse the certificate with a statement of the fact that it was taken and made before him, the date on which it was taken or made, and to sign such certificate. Once a person had been certified to be competent and the oath had been administered, then that certificate may be accepted as proof of the competency of the person to be appointed in the court concerned and of the fact that the person has taken the oath or made the affirmation. So for purposes of this section, in any subsequent proceedings before the court concerned, in other words, in any other regional court or district court of that division or that administrative region, it would not be necessary for the magistrate or the judicial officer presiding over the proceedings in the court to administer the oath or affirmation or to hold the inquiry into the competence of the person to be appointed as an intermediary. So the intermediary that has got the certificate would simply need to provide them with the certificate, and then that judicial officer do not need to hold the inquiry and to administer the oath again. It would be regarded that the person has been certified competent and has been sworn in. However, it is also stated in this provision that the paragraph must not be construed to prohibit a magistrate or a judicial officer presiding over proceedings from holding an inquiry at any stage of the proceedings regarding the competence of a person to act as an intermediary. Should there, in other words, be a concern by the judicial officer about the intermediary's competence to act as an intermediary in that specific case or for that specific magistrate, they can still then hold the inquiry. I thought it would be useful just to refer to the amendment of section 161, subsection 2 of the Criminal Procedure Act. That amended this subsection by taking out the derogative terminology deaf and dumb, and to change it that a witness that is lacking the sense of hearing or ability to speak be deemed to include gesture language, sign language, when we are talking about viva voce evidence, as well as that in the case of a witness under the age of 18 or a witness that suffers from physical, psychological, mental, or emotional condition, which inhibits the ability of that witness to give his or her evidence viva voce, be deemed to include demonstrations, gestures, or any other form of non-verbal expression in order to accommodate a witness. This would obviously include, for example, if they do a demonstration on the anatomical correct dolls, and or if they use any other form of non-verbal expression or gestures. For example, if they use some or other device that would assist them to express themselves, that is allowed now through the amendment in section 161, subsection 2 of the Criminal Procedure Act. Now, instead of just having the use of intermediaries in criminal proceedings and in a children's court proceeding, with the amendments to the Magistrates Court Act as well as the Superior Court Act, they can be used in all other proceedings as well. The provisions, the amendments between the two acts, the Magistrates Court Act and the Superior Court Act, actually reads exactly the same. So I'm not going to show two separate sets. Apart from the section numbers that differ, The content is the same for the two. And overall, the content is, with the exception of a word or two, very much the same as in the case of the Criminal Procedure Act. Oh, apologies. You will see from looking at the subsection 1, again, the court may on application or on its own accord appoint a competent person as an intermediary for all three different categories of witnesses under biological or mental age of 18 who suffers physical, psychological, mental, or emotional condition, or an older person, to give their evidence through an intermediary if it appears apologies, I'm talking too much. If it appears to the court that the proceedings would expose that witness to undue psychological, mental, or emotional stress, trauma, or suffering if they testify. One of the issues that previously had been raised, for example, is that if a witness, a child, for example, testify in the criminal case, they would be able to make use of an intermediary. But if there is a civil case for damages, for example, resulting from that sexual offense or what other offense, if they have to testify in a civil case, then they can't use an intermediary. And clearly that is a problem, that they're not being treated equally between the different types of proceedings. So with this provision now in the Magistrates Court Act, as well as the Superior Courts Act, it would mean that it doesn't matter what type of case it is, they would be able to use an intermediary. Similar to Section 170, capital A, these sections also provide that no examination, cross-examination, or re-examination, except examination by a court, may take place in any manner other than through the intermediary, that the intermediary may, unless the court direct otherwise, convey the general purport of any question to the relevant witness. Where the court appoints the intermediary, the court may direct that the witness give the evidence at any place that is informally arranged to set the witness at ease, that is so situated that any witness whose presence may upset that witness is outside the sight and hearing of that witness, and which enables the court and any person whose presence is necessary to see and hear either directly or through the medium of any electronic or other device the intermediary as well as the witness during his or her testimony. It also makes the same provision that the minister may determine the persons or category or class of persons who are competent to be appointed as intermediaries. Again, Virginia will talk about those determinations. Similar to Section 170, capital A, it provides that the intermediary appearing at proceedings in terms of this section who's not in the full-time employment of the state must be paid traveling and subsistence and other allowance. However, here, instead of the department or the minister doing the notice about the tariffs, here it would be the rules board that may have to make this determination as to what needs to be paid. And in this regard, Virginia will also elaborate a bit on that. If a court refuses an application or request for the appointment of an intermediary, immediately upon refusal, the court must give reasons which must be entered into the record of the proceedings. Similar to Section 170, capital A, And it also provides that the intermediary may be summoned on a specific date and specific place and time to act as an intermediary. It has got the similar provision in about should the intermediary is absent, become unable to act as an intermediary, or die, that the court may postpone to obtain the intermediary's presence, summons the intermediary to advance reasons for being absent, direct the appointment of the intermediary to be revoked and appoint another intermediary, or direct that the appointment be revoked and that the proceedings can continue in the absence of an intermediary. Again, the court must give reasons for any of these directions or orders that it is making, which must be entered into the record of proceedings. The oath to be taken is again similar to the one that we've seen in section 170, capital A, that's been included there. And it's got the same provision that regarding the elements to be looked at for the inquiry, as well as the same provisions regarding the oath and competency that can be done by the head of court to generally hold an inquiry and issue the certificate regarding competency and cause the person to take the oath, in which instance it does not have to be done in each and every trial, as long as they have the relevant certificate that is proof of the competency and the fact that the person has taken the oath. Again, the same provision that it should not be construed to prohibit a magistrate to hold an inquiry at any stage during the proceedings if they feel it's necessary, and it's got the same provision as to head of court. So intermediaries, because it's two different pieces of legislation, each needed to provide for the oath and competency, but as we will hear from Virginia, it can be done in respect of the provisions both in the Criminal Procedure Act as well as, for example, the Magistrates Court Act. For example, if by the head of the regional court president, for an intermediary to then be able to be utilized both in criminal and civil matters within the regional court, for example. I thought I should just quickly touch on two other amendments that was brought about. Section 158 of the Criminal Procedure Act that is dealing with the use of the CCTV or similar electronic media has been amended to state specifically that the witness can use this irrespective of whether the witness is in or outside of the Republic, and will be regarded as a witness who is subpoenaed to give evidence in the court if the witness is outside of the Republic and give evidence by the use of CCTV or some electronic media. That includes, obviously, remote audiovisual links through platforms such as the one we are now, Teams or Zoom. There's a similar provision that has been included in both the Magistrates Court Act as well as the Superior Courts Act that now specifically make provision in these two acts as well that a witness may give evidence by means of audiovisual link, regardless of whether or not they're in or outside the Republic. And the provisions otherwise of these new sections in these two acts reads the same as in the Criminal Procedure Act, section 158. as well. So I'm not going to go through all of that. I just thought that I need to just mention that specifically as well. So in this regard, these are the specific provisions in the Act itself that is of importance, in particular for your intermediaries, and would hopefully will hopefully make a big difference in regards to ensuring that our witnesses will find it much easier to testify, and that we are providing some better assistance and accommodation for them in order to ensure that they are able to properly participate in court proceedings, regardless of what type of court proceedings it would be. Thank you very much. Bryce, I'm handing back to you and to my co-presenter, Virginia. Thank you.
Thank you so much, RCP. This is the Regional Court President, Yaki Vessels, raised important issues that we need to consider. I think these are the groundbreaking changes that have been introduced, that now, for the intermediaries, they will be having now the oath and competency certificate. And I think that is a brilliant a change that has been brought by this act. So meaning that you are not going to be taken through this process of competency whenever you come. And secondly, that you will also then the ad hoc intermediaries, that you are calling them the ad hoc intermediaries, those intermediaries that are not in the government employ, so we'll be getting the traveling and subsistence allowance and other allowances. So meaning that then the rules board is setting the tariffs for the ad hoc intermediaries, which is quite a great innovation. And of course, it's going to be also be the department now also going through the process then of amending the current tariffs for the ad hoc intermediaries that are appearing in the criminal proceedings. So those the changes and that have been introduced and many more. So I would like then that all your questions, please put them on the chat, and we'll be getting now to the second presentation so that we get all these questions, all right, for both presentations. Now, the second one is coming to present is Miss Virginia Litswalo. Virginia is a state law advisor in the Department of Justice and Constitutional Development. Is coming from the private sector, is part of the team that put together the changes in the Criminal and Related Matters Amendment Act, particularly the provisions that deal with intermediaries. And she is also she participated in the drafting of a legislation to amend Section 7, subsection 3 of the Divorce Act to ensure that women who were married out of community of property in terms of the legislation applicable to former homelands benefit from the redistribution of property on divorce. She's also part of the team that has been put together to respond to the decision, the constitutional court judgment on the constitutionality of Section 9, subsection 1, that deals with forfeiture of patrimonial benefits on divorce. And other work that she's currently doing, she's drafting a legislation to facilitate the implementation of the Convention on the Rights of Persons with Disability. As you know that in South Africa, we are lagging behind in terms of implementing the Convention on the Rights of Persons with Disability. Before this webinar, I was in a meeting together with Ms. Yaki Vessels, where we were talking, discussing in how we can make our courts to be disability centric, and so she's part of that work. So welcome, Virginia. Thank you.
Thank you very much, Advocate Kambula, and good afternoon to everybody in attendance.
Hi, Virginia, before you can start, can you just try your camera is not really clear. I'm thinking that this is going to YouTube platform.
Yeah, I tried to wipe.
That's not working.
Maybe it's my lighting. Let me change my lighting.
I think it's gonna be dark now.
Is it dark now?
Yeah, no, it's not improving it. Virginia, I did not get the updated presentation.
Check your emails. It went through. I sent it through my my Gmail because our work email seems to be not working.
Oh, I just got it. Okay, don't worry, I've got it. Okay, I will put it up for you now.
Thank you.
Oh, apologies, everybody. I'm just sharing. No, now I'm sharing the wrong screen. Sorry. Hey, Virginia, I hope this is the right one.
May I request everyone to switch off the mic, the camera? Molalo, if you can switch off your camera, thank you.
Am I going to proceed?
Yes, please. The presentation is on the screen. Thank you.
Thank you. I've tried to improve the camera. I don't know what else to do. I hope it is better.
It's much
At this
better.
stage.
It's much
Thank
better.
you.
Thank you.
Okay. So, as Yaki has indicated that the Act, the Criminal and Related Matters Amendment Act, expands on the use of intermediaries in court proceedings. It provides for the use of intermediaries by more vulnerable witnesses, and it also provides for the use of intermediaries in proceedings other than criminal proceedings. Now, the Act in Section 1 and Section 18 also provides that the minister must determine categories of persons who may be appointed as intermediaries in proceedings other than criminal proceedings. That would be proceedings in terms of the Magistrates Courts Act and proceedings in terms of the Superior Courts Act. Now, we have developed draft notices for the determination of such intermediaries. That is the intermediaries that will be able to, that will offer services in proceedings other than criminal proceedings. Now, in addition thereto, because the Act also expands on the vulnerable witnesses who may use intermediaries, we have also reviewed the current determination of people who are competent to be appointed as intermediaries in terms of the CPA. We have included more categories because we anticipate that the use of intermediaries is going to be increased. So we wanted to ensure that we have a sufficient pool of people who are competent to be appointed as intermediaries. Okay, I'm going to take you through the categories of persons who are competent to be appointed as intermediaries. Yaki, if you could please take me back to the first slide. Let's go to the next one, slide number 3. Thank you. Slide number 3, please. Thank you. So currently, these are the categories of professionals who are competent to be appointed as intermediaries for criminal proceedings. It's pediatricians, it's psychiatrists who are both registered in terms of the Health Professions Act. It's clinical, counseling, and educational psychologists who have 2 years experience and are also registered in terms of the HPA. We also have family counselors who are appointed in terms of the Mediation in Certain Divorce Matters Act, and who also on top of that fall in any of the determined categories. Thank you. Can we move to the next slide, please? We also have social workers who have 2 years experience. We have educators, which includes also former and retired educators with 3 years experience and who are registered in terms of the South African Council of Educators Act. We also have child youth care workers with 3 years experience and are registered in terms of the Social Services Professions Act. Thank you, Yaki. So now those are our current categories of persons who are competent to be appointed as intermediaries. Now, because of the anticipated expanded use of intermediaries, we have added additional categories of persons who would be competent to be appointed in terms of who would be competent to be appointed to act as intermediaries. These categories are the general practitioners and family physicians, those are your doctors, who have 3 years experience and are also registered in terms of the Health Professions Act. We are also proposing that occupational therapists, speech therapists, audiologists, physiotherapists, and art therapists with 3 years experience and who are also registered in terms of the HPA be considered. We are also including professional nurses. Also included there is former and retired nurses, but they should have 3 years experience in a pediatric ward or a psychiatric ward and be registered in terms of the Nursing Act. Next slide, please. Okay. Now, we have also included these 2 categories of persons who may be competent to be appointed as intermediaries. We have early childhood development practitioners who are employed by an early childhood development center that is registered with the relevant government department. We've left it as a relevant government department because our understanding is that they will no longer be, they do not fall under social development anymore. They have been moved to Department of Basic Education. And we also have community trauma counselors who are employed by an NGO. Now, with regard to these 2 categories, we have proposed that they both have at least 10 years experience because they might not have formal qualifications in the form of your degrees or diplomas, because their areas do not necessarily require that they have such qualifications. But we are of the view that especially community trauma counselors, that they do have an important role to play in the provision of intermediary services, on the basis that these are the people that work with people who are dealing with trauma, one kind or another of a trauma that they have gone through or that they have witnessed. And we also proposing this category on the basis of the fact that South Africa do have a policy on the recognition of prior learning, which now enables a person who does not have the formal qualifications like your degrees or diploma to be considered for certain positions on the basis of the extensive experience that they may have in that area. Thank you, Yagi. Okay, the determinations further provides that any person, even if they do fall under any of these categories that I have just listed, they do not qualify to be appointed as intermediaries if their names appears on any of the registers rather contemplated by any of these provisions. Like, for instance, a register in terms of Section 42 of the Sexual Offences and Related Matters Amendment Act. Those would be the people whose names appears on the register of national sexual offenders. Also, those people or persons whose names appear on a register compiled in terms of Section 31 of the Older Persons Act, or a register in Section 9 of the Children's Act. Now, these people may not be appointed as, they do not qualify to be appointed as intermediaries, even if they fall under any of the categories that have been mentioned in the previous slides. Thank you. Now, as Yaki has pointed out in her presentation, the Act provides that a head of a court may decide at their own discretion to issue a certificate to a person they have found to be competent to appear as an intermediary after such head has held an inquiry to inquire into that person's competency to appear as an intermediary in court proceedings. Now, the Act further provides that the minister must prescribe a form of a certificate that this head of a court would issue to this person they have found to be competent to act as an intermediary. Now, to this end, we have developed a pro forma certificate which facilitates the recording of information about the intermediary, which information would now have been established during the process of the inquiry. The information that will be recorded on the certificate includes the person's names, contact details, their qualifications, their years of experience, and professional registration details. Language proficiency, including sign language and foreign languages. Thank you, Yaki. We can move forward. Okay. Now this are now the functionaries who may issue such a certificate. It would be the Chief Justice with regards to proceedings in the Constitutional Court, the President of the Supreme Court of Appeal with regards to proceedings in the Supreme Court of Appeal, a Judge President of a division of the High Court, or a senior judicial officer of a court in the Magistrates Court. These are now the provisions in the subordinate legislation, that is the determinations that would be made by the minister to provide for the certificate and the categories of persons who are competent to be appointed as intermediaries. Now we have kept the categories of persons who are competent to appear as intermediaries for both criminal proceedings and non-criminal proceedings at the same. So if you are competent to appear as an intermediary for criminal proceedings, you would in the same breath also be competent to be appointed in proceedings other than criminal proceedings. Thank you very much. That's it from me for now.
Thank you, Virginia, and thanks for the presentation, quite informative. And this is the information that I believe that many of us who are in this platform would like to have, all right? So now because I'm gonna be opening now the platform for us to ask questions, but I just want to give you just a takeaway from these two presentations. The first is for us to know that the intermediaries, this is what we have received, that the intermediaries now will be getting the certificate of competence that will be issued by certain categories of the judiciary that have been mentioned here. And then secondly, as a takeaway, is that now the ad hoc intermediaries, that is intermediaries that are not in the government employ, are recognized now by the legislation, which is quite something that is very innovative, because it means that they will be protected now by the legislation. And they are entitled to the traveling and subsistence allowance, and the tariffs, they must be set by the rules board, and the intermediary services are now extended to civil proceedings. So we have the current pool that is focusing on criminal matters, and then now their scope of services has been extended to civil proceedings as well. So now, and in civil, for those who are already in the government employ, they will be doing both the criminal and the civil proceedings, appearing in both those proceedings. For the civil, they will be appearing in maintenance matters, all right, in terms of the Maintenance Act. They will be appearing in the civil applications for the Protection Order in Domestic Violence Amendment Act. They will also be appearing, they're already appearing in proceedings held in terms of the Children's Court Act, the Children's Court Act, and protection from the Harassment Act, and what is the other one, which is the one that the Criminal and Related Matters Amendment Act and Sexual Offences Courts. But then we also have those pieces of legislation that provide both the criminal and the civil proceedings. So we'll be using them. So the job description now is being reconfigured so that it is aligned with these amendments. And the other takeaway is that different people who have been selected here that will be participating, that are considered as competent to participate as intermediaries and so that's the information that we have received. And the audio visual link testimony, so that's gonna be I mean, it's a great innovation, particularly for persons with disability who can come to court, older persons who can come to court, and even the traumatized witnesses who say that, you know what, I don't want to get into that space for different reasons. And we have the audio-visual link testimonies that will be taken. Great innovations. Now I'm going to be opening us now to ask questions. But first, I would like just to start with the questions that are already on the chat. All right. So the first there is coming from Delia. Could you please? Okay, so this is the one to be added in the. All right. So we will do that, Delia. And now Joan is asking, what about the paralegals, particularly in rural areas where there are few other professionals? And Peter is also asking, are certified and accredited mediators not considered eligible by profession? All right, then we also have the other one that is coming from Lihodu. Noting proposals with regard to retired nurses, any view in terms of consideration for retired social workers and social work veterans, right? We want to know. Those are the questions. And Peter is also asking, why discriminate against the older persons by disqualifying this category? All right, is it really in terms of the Constitution? All right, let's take these questions first, and then after that, then I'll be opening for the audio questions. Thank you. Virginia.
Thank you. With regards to retired social workers, there really is no reason why they should not be considered.
Sorry, Virginia, would you switch on your camera?
With regards to retired social workers, there really should not be any reason why they should not be considered, especially if even after retirement, they do retain their membership of their professional body, as it is the case with retired educators and retired nurses. And with regard to mediators and paralegals, we did not consider these two categories, and I am sure there's also lots and lots and lots of other professionals or other categories that would be suitable to act as intermediaries who are not in this list. This list is not exhaustive, and this determination, luckily, it's secondary legislation, so it's very easy to include or to extend the list as and when it becomes necessary. So they are not appearing in the current categories, not because we did not think that they were not competent. We did not consider them during the first drafts, and even after public consultation, they were not they were not suggested or proposed. Thank you very much.
All right, it's my follow-up then on this. Is there any opportunity of you including them at this stage?
Thank you, Chair. Because we have committed to bring this act into operation on the 31st of July, and it's about 3 weeks away. I don't think it's really feasible to include them now, but we should just keep on mind that determinations are very easy to withdraw and replace. It's not a cumbersome process to withdraw an existing determination or to amend it, because it's a legislative instrument that is developed by the minister. It does not involve Parliament. So it is something that they could be included at a later stage. It is a change that can be made at a later stage, and it's going to be very easy to do it, like I say, because it's not a cumbersome process for ministerial determinations, as the process is very short. But it's not advisable to do it immediately, because the current determinations are at a very advanced stage, and we cannot delay the coming into operation of the legislation at the stage. Thank you.
Thanks, Virginia. All right, for those who have asked these questions, I just want you to commit that praise will ensure that this are included. We will ensure that this thing is done, to include the retired social workers and so on. And because as I'm listening now, I'm finding that they should have been included. All right, so any questions? Now it's open for questions, the audio questions.
Bryce, maybe before you do that, I saw that there were a couple of questions about the certificates, including whether or not it would be valid for a specific period only, and whether or not the head of court that issues such a certificate would do an inquiry as well. Yes, I cannot, as a head of court, issue the certificate unless I do an inquiry. I have to satisfy myself that the person comply with all the requirements and make the determination regarding competency. Also, because there's a distinction between the different categories as to whether it would be competent in respect of, for example, children or older persons or people with, or the third category, I would be able, I should, or I have to specify which category of person that person would be able to be an intermediary for. So I can only do that with the inquiry, and satisfying myself that the person comply with all the requirements, including, for example, registration, etc., etc. Because some of the registrations specifically is yearly registrations. Obviously, where it's yearly registrations, my competency certificate can only be for that year period, or the period that is left on that registration, because it would be dependent on the fact that if the person is not a registered social worker, for example, and they have to do yearly renewals of registration, obviously, as soon as that year period is passed, I would need to satisfy myself again that a person is still registered in order for the competency certificate. So from that perspective, one would need to make sure that, I can't give a competency certificate and then the person never again register and that it would still be applicable. So it can't work like that. It can only be for the period that the person would be registered, for example. Obviously now, which we didn't previously have, is the issue of the, what shall we call it, clearance certificates from the different registers. We need to be satisfied about that as well. So people would have to get regular clearance certificates for whichever period, for example, the registration would be applicable when they apply again. I saw there was a question about the qualities of a good intermediary, etc. I do think it is very important to also understand the role of the intermediary. The intermediary here is the conduit between the court and the witness, and in conveying the questions to the witness in a manner that the witness would be able to understand that. So a good language abilities is extremely important. The ability or the understanding of the developmental level of the witness, in particular when you're dealing with children, those with mental disabilities, is very important. But because of the new categories, for the traumatized witnesses, an understanding of the impact of trauma on the ability of a witness to be able to be responsive to questions, etc., would be important. So that is why you may be certified competent to be a witness with regard to children, for example, but not necessarily for people with an emotional or a psychological condition and or an older person necessarily, because of the fact that it will depend on the experience and the understanding of the ability to work with that specific category of witness as well. So there are a variety of other new factors that we would need to take into account. And that is also why during a proceedings, if a presiding officer picks up that this witness does have problems to properly communicate or assist this specific witness, they can relook into the competency to satisfy themselves as to whether or not this is actually the right intermediary or the intermediary with the right type of experience and understanding for this specific witness that is testifying. I hope that would be assisting. I know that I saw some questions there about training, etc.
Yeah. I think you can also take this one, Yaki, which says it's coming from Hoitsimang. Will the renewal certificates of the CI require payment as we do with other professionals?
Now,
will these certificates be paid for?
The certificates that would be issued by the heads of court, there's no payment.
There's no payment.
There's no payment for that. Yeah, there's no payment. The arrangement would just need to be made with the head of court to get the certificates. Just remember that is not the only option. If you don't have the certificate, then we still follow the proceedings the procedure we've always used of doing it in court prior to the witness testifying. It may now take a little bit more than 20 minutes because of the fact that there are very specific additional aspects that the presiding officer must be satisfied of that is now prescribed in the legislation that had not previously been prescribed in the legislation, in order for the court to be able to prescribe, appoint the intermediary as competent intermediary for that specific case. So there's just a little bit extra. So having the certificate makes it easier for the period that the certificate is there, in that as presiding officers, we do not need to then do the competency certificate, a competency inquiry in court and the swearing in court. I hope that clarifies it.
Thanks, Yaki. And now there is also another question before I can get to other questions, the audio questions. Is asking, will persons with disabilities and parents be included as well? All right. Parents of children with disabilities and also persons with disabilities, will they be considered as competent intermediaries? And also the accredited mediators. Would you please respond, Virginia?
Thank you. Yes, persons with disabilities who are suitable or who are in a position to offer the intermediary services, they are not excluded so long as they fall under any of the categories that are determined, and they have the prescribed years of experience and the required qualifications, but also so long as they will pass that inquiry, or that a court or the head of the court must hold before any person at all may be appointed as an intermediary.
Thank you.
They are not excluded. Thank you.
All right. Thank you so much. Now we're going to be getting to the... All right, let me just get there so that I can. All right, and then these are the questions I'm giving you. I'm recognizing these hands in this sequence. All right, we will start with Peter. Peter will be followed by Katekani, and then the third one will be Gregory in that sequence. Thank you.
Thank you, ma'am. Thank you very much. Good afternoon, everybody. I posed a question in the chat, which wasn't addressed, my second question, so I will take the liberty, if I may, to pose it verbally now. It seems that the eligible categories for the appointment of intermediaries are at odds with one another if one juxtaposes the fact that older persons are disqualified, those that are registered on the Older Persons Act, so I assume those females at 90, 60, and gentlemen or men at 65, when it's compared to retired nurses and other retired categories, and one would assume that one retires at 60 and 65 in most instances, in companies in the state and so on. So there seems to be an inconsistency in that case. So if you could address that then specifically for me, I'll be very grateful. Thank you so much.
Thank you, Peter, for the question. And let's get it to Katekani. And Katekani, if you can also switch on your mic, if you may.
All right. Thank you very much, colleagues. This is Tabang Lishabana from Katekani Community Project. My question, I would like to know, because in other professions, there is a certain body that an individual has to register with. And then in terms of paralegals, there is no, at this point, a legal body that paralegals have to register with. So I would like to know, because you said, I think you mentioned that the certificate, for it to be active, one has to be legally registered with the body that is regulating that certain profession. So I'd like to know, in terms of paralegals, how is it going to work out? Thank you.
Thank you, Gregory.
Good afternoon, Praise. I think a couple of things which have been raised here today is very good, but what I'm trying to find out from you that if a particular foreign national do have a qualification and he or she is not resident with any boards in a country, one, and he got experience to be intermediate, will he be accepted as one? Two, the issue of rural areas where there's a scarce skills of qualification, how then will be able then to filtrate the process of seeing to it that they also get the same type of services as other areas in metro and in urban areas as well. Thanks, Advocate.
Thank you. All right. Let's get then to our presenters to respond to these three questions.
Thank you. I will start with the last question with regards to foreign nationals who do qualify or fall under any of the categories of persons who are competent to be appointed as intermediaries. The determinations do not refer to nationality or citizenship, so they are not excluded currently as the determinations stands So they are not excluded. They do qualify to be appointed as intermediaries. The law does not exclude them at this stage. With regards to the provisions of the determinations being at odds with each other, maybe I should have clarified during my presentation, that those registers that I referred to, that is the register in terms of the Children's Act, Older Persons Act, and the register of in terms of sexual offenders. Now, these registers, that is where the names of persons who have offended against any of these vulnerable people, like who have offended against older persons or children, are recorded. Now, because they are offenders against these categories of persons, they are not competent to be appointed as intermediaries. So the provisions are not at odds with each other. Their exclusion is aimed at affording more protection to the vulnerable groups. I hope it makes sense. And another question spoke to professional bodies, specifically with regards to paralegals. We at this stage do not have paralegals on categories of persons who are competent to be appointed as intermediaries, but it's similar to the two new proposed categories. That is your community trauma counselors and your early childhood development practitioners. Well, they do not, there isn't at this stage any professional body that regulates them. That is why the determination says that the only requirement is that they be employed by an organization that is recognized by a department, a governmental department, for instance, an NGO that is registered with Department of Social Development, or an ECD that would have been also registered with the Department of Social Development. Thank you.
Thank you, Virginia. RCP? Any question that you would like to respond to?
Yes, there's a couple of questions that I picked up on the chat. About the training, Justice College provides training for intermediaries that have been appointed within the Department of Justice. I'm unfortunately not sure. I remember years ago they did do some training for intermediaries that's not within justice, but as to what the current situation is, I'm not sure. I'm sorry to say. I don't know if somebody from the intermediaries might be able to actually assist there. They were asking about how to access or how to get the certificates of competency. You should then approach the Office of the Chief Magistrate, that is the head of the administrative region for that area for district courts, and the Office of the Regional Court President